नमस्ते फ्रेंड, आप सभी का एक बार फिर से वेलकम। फ्रेंड्स, श्री सीएन वेणुगोपालन जो हमारे पेंशन एक्टिविस्ट हैं, एक्स मैनेजर यूनियन बैंक ऑफ इंडिया ने एक पत्र मई 29 को चीफ जस्टिस ऑफ इंडिया सुप्रीम कोर्ट को लिखा। मोस्ट रिस्पेक्टेड चीफ जस्टिस, सब्जेक्ट इंडियन बैंक एसोसिएशन एंड कंटेम्प्ट ऑफ सुप्रीम कोर्ट। द इंडियन बैंक एसोसिएशन, the unregistered association of banks in India, caused United Bank of India, now Punjab National Bank, filed civil appeal number 5252-5255 of 2018 before the Honorable Supreme Court of India for denying the payment of 100% dearness relief neutralization to the pre-November 2002 bank retirees and secured a favorable judgment through unfair means. The Department of Financial Services, representing government, also joined hand with IBA in the mission. The bank and the IBA tricked the Supreme Court. The Kolkata-based United Bank of India produced before the court the pension regulation of the Mumbai-based Union Bank of India, and the pension regulation of the former were not amended to suit the requirements of the suit for bettering the court for getting the favorable judgment. The judgment in civil appeal 5252 to 5255 came out on 16 May 2018. On 2nd April 2018, the DFS had written to the United Bank of India that the amendments carried out to its pension regulations were irregular and it may be notified in the Gazette again. The irregularities pointed out by the DFS were that instead of showing the name of United Bank of India, the name of Reserve Bank of India was shown, and the notification was issued in the name of the Ministry of Finance instead of United Bank of India. The DFS had also sought explanation for the delay in notifying the amendments in the Gazette. There was not time in between the date of the letter of the DFS and the date of the judgment to amend the pension regulations of United Bank of India by following the due procedure in law of laying the amendments before both the House of the Parliament as mandated under section 19(1) and 19(4) of the Banking Companies Acquisition and Transfer of Undertaking Act 1970. The bank was seemingly betraying the Honorable Supreme Court by producing the pension regulation of Union Bank of India instead of producing its own pension regulations. A jolt of the Honorable Supreme Court. The IBA later recommended to pay 100% DR neutralization to the pre-November 2002 retirees, and the DFS sanctioned it from 1st October 23, depriving the benefit for 221 months from 1st May 2005 to 30 September 23 through its letter dated 5th October 23 to the IBA with a postulation that no arrear shall be payable for the period falling before the effective date. The act of the DFS was making it clear that the ruling dated 16 May 2018 of the Honorable Supreme Court in Civil Appeal number 5252 to 5255 of 2018 was unfounded. The stipulation in the letter dated 5th October 23 of the DFS that no arrear shall be payable for the period falling before the effective date was making it loud and clear that the pre-November 2002 bank retirees are entitled to the arrears of 100% DR neutralization, and that the DFS was trampling upon the law laid down by the Honorable Supreme Court on 4th May 1971. In Devkinandan Prasad versus State of Bihar where it was held that the pension is not subject to the discretion of the government and that payment of pension is subject to rules. On informing the matter to the Secretary Financial Sector, finding nothing amiss in it, he said on my letter dated 6/11/23 for about 2 months off and thereafter forwarded it to the IBA on 10th January 24. In abdication of the responsibility, knowing well that the IBA is a mere voluntary association and cannot do anything in the matter. Judicial catastrophe was arising out of the judgment dated 16 May 18 in civil appeal 5252 to 5255 of 2018 through the malicious acts of United Bank of India, Indian Bank Association and DFS in the sense that first, it escaped the attention of the Honorable Supreme Court that the appellants played foul on its producing the pension regulation of another bank. Second, the court relied fully on the joint note dated 2nd June 2005 between IBA and bank unions without cognizance that these parties cannot override the statutory pension regulations. 3. A co-equal branch of the court had delivered a judgment on 13 February 2018 in civil appeal 525 of 2012 Vijay Bank of Baroda and versus G. Palani and others, where it was held that the joint note cannot supplant any of the provisions of the pension regulations which are statutory. The ruling dated 16 May 2018 in civil appeal 5252 to 5255 of 2016 was per incurium of the ruling dated 13 February 2018 in civil appeal of 5525 of 2012. Fourth point, the Honorable Supreme Court reached a wrong conclusion in the ruling dated 16 May 2018 that if the pre-November 2002 retirees are given 100% DR net license, it would give them more pension than the post-November 2002 retirees without knowing the assumption was incorrect. Fifth, the ruling dated 16 May 2018 has resulted in each pre-November 2002 losing a part of his pension, which is his property, for a period of 221 months from 1st May 2005 to 30 September 2023, which can be quantified between 5 lakhs to rupees 10 lakhs, excluding interest for the delayed payments. Actus curiae nemen gravit. Applying the legal maxim actus curiae nemen gravit, the ruling that dated 16 May 2018 is making it imperative that the Honorable Supreme Court shall direct the Department of Financial Service IBA to neutralize the loss caused to the pre-November 2000 bank retirees. It also needs that the Department of Financial Services IBA are censured for acting sans probity in the centennial of the justice, which amounts to contempt of the court. A copy of this letter is being sent to the DFS IBA with a request to revisit the sanction and to pay the arrears of 100% DR net license to the pre-November 2002 retiree bank retirees forthwith, or to inform to your lordship if there is anything amiss in this letter. Yours faithfully CN Venugopalan. और इसकी कॉपी DFS IBA सेक्रेटरी ऑफ फाइनेंशियल सर्विसेज चेयरमैन इंडियन बैंक एसोसिएशन को भी किया गया है। इस पत्र का मेन मुद्दा क्या है कि जो 2002 प्री के रिटायरीज हैं जिनको 100% DR नेट लाइसेंस के लिए अप्रूवल था, उनको प्रोस्पेक्टिव डेट्स, रेट्रोस्पेक्टिव डेट नहीं, प्रोस्पेक्टिव डेट से होना चाहिए, उनको एरियर मिलना चाहिए 2005 से अपडेट तक का। थैंक यू फ्रेंड्स, नमस्कार।